So where is the line? When does a journalist's hard-hitting expose cross over into being an actual crime? We're going to dive into a landmark case from the Cayman Islands where free speech went head-to-head with online harassment laws. And believe me, this legal fight has huge implications for journalists, politicians, and really for any of us who use our voice online.
Okay, let's just jump right in with the single most provocative statement from the whole first trial. The judge basically ruled that the truth didn't matter. You heard that right. He said you could be harassed by true statements just as much as by false ones. And that one idea, wow, it set the stage for a massive constitutional showdown.
And for this entire story, our guide is the official Court of Appeal judgment itself. We're going straight to the source, unpacking every detail of this incredible case, right from the legal documents. So how did this whole thing even begin? Let's break it all down. What was said, who was involved, and the exact law that was supposedly broken. All right, let's meet our key players. You've got the podcaster Sandra Hill, who released what was described as a hard-hitting expose about Matthew Leslie, who just so happened to be a political candidate running on a platform of transparency. Now, the court ended up calling the podcast a character assassination because it had some pretty serious allegations about his personal life. Hill, for her part, completely stood by her reporting, saying she believed it was all true.
The charge against Sandra Hill all came down to this one law, Section 90 of the ICT Act. And the wording here is everything. The law makes it a crime to use an ICT service, so, the internet, to abuse, annoy, threaten, or harass. Just think about how incredibly broad those words are, especially annoy and harass. And that really broad law, it led directly to the first trial's most controversial moment, a decision that would become the absolute central battleground for the entire appeal. Okay, so this was a pivotal moment in the courtroom when Hill's defense team tried to question Leslie to actually check if the podcast's claims were true. The judge shut them down. He flat out ruled that whether the statements were true or not was irrelevant to the charge of harassment, which echoes that wild judgment we saw a minute ago. So, with the truth off the table, Sandra Hill was convicted. She was fined 3,000 Cayman Islands dollars and slapped with a restraining order. The message from the court was loud and clear. Even if what you're saying is 100% true, you can still be found guilty of a crime if it harasses someone. But that wasn't the end of it. Now we move to the appeal, and this is where the case just explodes into a full-blown debate about constitutional rights. The stakes get so much higher. I mean, look at this. It's a legal collision course. On one side, you've got the super broad, kind of vague language of that ICT law. And on the other, you have Section 11 of the Cayman Islands Bill of Rights, which guarantees freedom of expression. So the big question for the Court of Appeal was, can a law against being annoying actually override a fundamental constitutional right? And this is where the story takes a truly wild turn. The document you're seeing right now isn't from the defense team, no. This is from the prosecution, the ones who brought the case against her in the first place. Yeah, you heard that right. In a pretty stunning move, the prosecution basically admitted the original conviction was a mistake. They actually stood up and formally invited the court to throw out the conviction, saying the first judge had made an error of law. They essentially switched sides. So, okay, with both the defense and the prosecution now pretty much in agreement, how did the Court of Appeal manage this? How did they resolve this clash between protecting people from harassment and protecting the fundamental right to speak freely? Well, what they did was create a brand new 5-part test to figure out what counts as criminal harassment. First, they said the speech has to be more than just offensive or shocking. Second, courts have to give a ton of weight to free speech. Third, context is absolutely critical, especially for political speech. Fourth, public figures, well, they just need to have thicker skin. And finally, and this is the big one, in a complete reversal, the court said the truth of a statement is plainly highly relevant. So, in the end, the Court of Appeal looked at the original trial through this new lens and found that the first judge had pretty much failed on all counts. He didn't properly consider the political context, the higher tolerance we expect from public figures, or, and this is the most important part, the relevance of the truth. Okay, so let's zoom out. What was the final verdict? And what does this landmark decision really mean for speech in the Cayman Islands? And maybe even beyond? The final outcome was decisive. The Court of Appeal allowed the appeal, and the conviction against Sandra Hill was officially quashed. Just gone. It was a massive victory for freedom of expression. But wait, the story has one more twist. On the left, you see the successful appeal we've been talking about. But on the right,
That's a new summons, issued months later, charging Hill with a similar harassment offense, just under a different law. It really seems this legal battle is far from over.
And that really leaves us with the million-dollar question that legal systems all over the world are struggling with right now. In our super-connected digital age, where exactly do you draw the line between protected free speech and criminal harassment?
So imagine this. A podcast host, right? She runs a really critical, hard-hitting online show, and she gets convicted in court.
Yeah.
Not just convicted, but hit with a massive fine. And the reason? Because her content was found to be, and I'm quoting here, intensely annoying under a modern technology law.
We're talking a literal conviction for character assassination. But then, and this is the amazing part, the absolute highest court in the land steps in.
Right.
They look at the case, but through this lens of, fundamental constitutional rights, and they throw the whole conviction out.
That whole dramatic clash is exactly what we are deep diving into today. This is the landmark case of Sandra Teresa Hill v. H.M. the King out of the Cayman Islands.
And it is a perfect storm, really. You have these new, often very broadly written information and communications technology, or ICT laws. And they just run head on into this deeply protected fundamental constitutional right of freedom of expression.
Okay, so let's break this down for you. You've got a law that makes being annoying a crime on one side. And on the other, you have the Bill of Rights. So our mission today is to really trace that legal path and get our heads around the core concept that saved her, which is proportionality.
Exactly. Proportionality. It's this legal calculus that basically decides when it's okay to criminalize speech. And as we'll see, why that bar has to be set almost impossibly high when that speech is aimed at a public figure.
Right. We want to give you some real insight into the hierarchy of protected speech in a democracy.
Because not all speech is created equal in the eyes of the law. And political speech, that sits right at the very top.
So let's start where the trouble started, the podcast itself. The host is Sandra Teresa Hill. She runs the Cayman Marl Road, or CMR, website and podcast. Who was she going after, and what was in this relentless onslaught?
So the target was a man named Matthew Leslie. And he wasn't just some private guy. He was an active politician.
Okay.
He'd stood in 2 different elections, and his whole platform was built on transparency and trust. Hill's podcast was this hour-long, comprehensive expose. And the trial judge, he later called it a character assassination, a relentless onslaught on Leslie's professional and personal life.
And the allegations were pretty severe, right? This wasn't just minor stuff.
Oh, not at all. They described him as a sexual predator, said he was dishonest in his business dealings. This was hard-edged, reputation-destroying stuff.
Yeah.
And the trial judge, Justice Chappell, he saw that. He described Hill as being completely obsessed with her crusade against Leslie, lacking any objectivity. But, and this is the first really crucial twist, the judge also put it on the record that he believed she thought what she was saying was true.
That distinction, her belief in what she was saying, that's going to be important later.
It's going to echo through this whole thing, yeah.
Now, she was convicted under a very modern law, the ICT Act. Can you walk us through that specific piece of legislation?
Sure. It's Section 90, subsection 1 of the ICT Act. And it casts this astonishingly wide net. It makes it a crime to use an ICT network or service to do fraud, abuse, annoy, threaten, or harass any other person.
Just annoy.
Annoy. Think about that for a second.
So the law is basically saying that if you knowingly use the internet, say a podcast platform, and as a result, anyone gets annoyed, you can be guilty of a crime.
That's the implication. It's a massive potential chilling effect on any kind of online commentary.
I'll say.
And based on that, she was summarily convicted. So no jury fined 3,000 Cayman Islands dollars and slept with a restraining order restricting her use of communication networks. A huge price to pay for a podcast.
Okay, and this is where the real courtroom drama begins, because the trial judge made a mistake that the appeal court would later call plainly wrong.
Right.
When Hill's defense team tried to bring in evidence to prove her claims were true, the judge just stopped them. Why?
That was his core error. He ruled that truth was completely irrelevant under the ICT Act, and his logic was all about the statute. He compared this new tech law to the old criminal libel law. The old law has a specific defense. It says you're okay if what you published was true and for the public benefit. Since the ICT Act didn't have that clause, he just assumed the legislature meant to exclude truth as a defense entirely.
Wait, hold on. So because the law didn't specifically say it's okay if it's true, he decided it's a crime whether the allegations against a politician are stone-cold facts or not.
That is the stunning conclusion he came to.
Yes.
Yes. He essentially made the prosecution's job incredibly easy. All they had to prove was, 1, she used the network, 2, the politician was in fact annoyed or abused, and 3, she knew this would be a likely outcome. He just sidestepped the whole messy business of truth.
I can see why that conviction was appealed almost immediately. I mean, when you take away the ability to even argue the truth of claims against an election candidate, that's a problem.
It is, but to be fair, the judge did tip his hat to a higher power. He acknowledged that Section 11 of the Bill of Rights, the part that guarantees freedom of expression, was engaged. He knew it was in the room, but he thought he'd already balanced it against the politician's reputation just by applying the rules of the ICT Act, the Court of Appeal. Oh, they fundamentally disagreed with him on that.
Which brings us to the appeal, the constitutional heavyweights. And it's pretty telling that the Director of Public Prosecutions, the DPP, actually conceded the appeal.
That's huge, yeah.
They basically admitted the judge got the law wrong, that the whole case was built on a legal mistake.
Exactly. And that just cleared the runway for the appellate court to do what it does best. Focus on the explicit constitutional protection. They zeroed in on Section 11 of the Bill of Rights, which, just for context, is basically identical to Article 10 of the European Convention on Human Rights.
Meaning they can draw on all this foundational free speech precedent from the UK and Europe?
Precisely. They were forced to apply the highest possible standard here. And that means using the proportionality test.
We hear that term a lot. In this context, what does that test actually involve?
It's a 3-part test. It's like a series of gates the state has to get through to justify restricting speech. First is the interference, the conviction prescribed by law.
Yes, the ICT Act.
Okay. Second, is it for a legitimate aim?
Protecting someone's reputation.
Yes.
Yeah.
But then you get to the final and highest hurdle. Third, is the conviction necessary in a democratic society?
That's a proportionality test. Is this the absolute minimum required?
That's it. And the court immediately pointed to this key UK case, R v Casserly, which established that just because you prove the ingredients of the crime, like you prove someone was annoyed, that does not automatically mean the conviction is proportionate or constitutional.
But that is such a critical distinction for you to grasp. You can prove annoyance, but that doesn't automatically give the state a green light to criminalize the speech that caused it.
Not at all. And the appellate court said the trial judge completely failed to consider 3 core principles from that Casserly case. These are absolute cornerstones of free speech law.
Okay, let's spend a minute on these because this is the real takeaway. What's the first principle he missed?
First, you have to give great weight to freedom of speech. It's a fundamental value. It's not just a nice to have. It's essential for a democracy to function. So it should always be the dominant right when you're balancing it against something like, preventing offense.
So practically speaking, that means if a law is ambiguous, you have to choose the interpretation that favors free speech. The law has to bend to the Constitution, not the other way around.
Exactly. The second missed principle was about the target. The judge didn't consider the need for tolerance, especially from people in public positions.
People like Matthew Leslie.
People who choose to run for office. I mean, if you stand for election on a platform of transparency, you're actively inviting intense scrutiny and criticism. You don't get to turn around and claim criminal harassment just because that scrutiny stings.
Right. Public figures have to have thicker skin.
The courts have said it time and again. And that leads to the third and, in this case, most powerful principle. The particular weight you have to give to political speech.
Political speech.
Yes. The court called it the apex of protected speech. It's the most vital kind of speech for a democracy. So when you have speech that targets an election candidate about issues like trust and transparency, any attempt to criminalize that has to clear an almost insurmountable constitutional bar.
So the second this was identified as political commentary, the judge should have realized that a simple annoyance clause in the ICT Act was probably not going to be enough for a conviction.
He should have. The big takeaway here is that a government can't use these general anti-harassment laws to shut down robust or even harsh political criticism. The annoyance caused by that kind of critique is just. It's the cost of doing business in an open democracy.
Which brings us right back to the judge's first error, throwing out the evidence about truth. If the ICT Act didn't list truth as a defense, why did the appeal court say it was still relevant?
Because the constitutional proportionality test demands it. The appellate court said the truth or falsity of her claims is plainly highly relevant when you're deciding if criminalizing the speech is proportionate. They said there is, and I'm quoting, a significant difference in criminalizing the expression of what is or may be true and criminalizing what is false.
So even if the ICT Act was silent, the Bill of Rights was shouting. If the claims are true, or even potentially true, the state has far less reason to interfere than if the claims were just made up.
Precisely. The judge should have at least let the trial continue to test her claims. And beyond that, the court also pointed to Hill's own belief. Her sincere belief that what she was saying was true. That should have been an important element in the judge's proportionality calculation.
But surely there has to be a limit on that. I mean, you can't just excuse libel by saying, well, I believed it, if there's no basis for that belief.
And that is the crucial qualifier they added. The court was very clear. Her belief is only relevant if it was based on a reasonable assessment of the available evidence. It can't be a belief you reach with any sound basis. So that protects genuine reporting, but it doesn't give a pass to just being reckless with the facts.
Okay, so let's pull this all together for you. You have a podcast host making intense, maybe even abusive claims against a public figure, causing real distress, and yet the conviction gets overturned. What's the fundamental lesson?
The ruling is this incredibly powerful statement. It says that criminalizing speech against a public figure, even if it's annoying or abusive, must satisfy that high constitutional bar of proportionality. The distress caused by political critique, even when it's packaged aggressively in a podcast, can't just automatically override the high-level protection for political free speech.
So this sends a pretty strong message to governments everywhere who are writing these new tech laws. You can't draft them so broadly that you accidentally make legitimate political criticism illegal.
And the court was careful. They said quashing the conviction doesn't mean a conviction would never have been possible. For instance, if the speech was proven to be totally false and malicious, maybe. But they also noted that 6 years had passed, and a retrial just wasn't in the public interest anymore.
And just to show you this isn't some historical case, but a live issue, our sources show that Mrs. Hill is still navigating these waters. Around the time this appeal was decided, she was charged with new offenses under the Penal Code for harassment, alarm, or distress.
It's the continuing push and pull, isn't it? Individuals like Hill who use these platforms for aggressive, targeted criticism are always going to be bumping up against harassment laws. And the courts are constantly being asked to walk this tightrope. Where does the right to speak end and the right to not be criminally harassed begin?
And the Hill decision really draws a clear line in the sand for political speech.
It does.
So that's the core truth here. In a democratic society, you have to interpret your laws to give great weight to freedom of expression. Annoying a public figure with potentially true claims is not, by default, a crime. Proportionality is the key.
Which brings us to a final thought for you to take away. The court recognized that the language in that ICT Act, words like annoy, harass, abuse, is just dangerously vague for political discourse. So here's the question. As our digital world keeps evolving, are our legal systems actually capable of defining with enough precision where robust, aggressive free speech ends and where criminal harassment of an official begins? That battle over what is necessary in a democratic society is, I think, just getting started online.